for the day, my lord. Immediate in the next week, lordship.
The order is in force.
Yes, lordship. Immediate in the next week, my lord. We will not begin. Just for today, my lord.
Mr. Lal, it appears that there is an objection because you made it yesterday. The public prosecutor has
Yes,
objected.
I was told, my lord, by my learned friend, my lord. Only for today, I am praying for an adjournment, my lord.
Let us see the matter. Let the matter reach. If the matter may not reach,
Lordship, I have some difficulty today.
consider. We'll consider. We'll pass the order on the matter reach. Okay, not at this.
Lordship.
Yes, we'll pass the order on the matter.
Lord. Maybe I beg to mention listing a order from petition, my lord. I'm for the respondent. Petitioner enjoyed the stay order. It was listed, my lord, 15/12/2023, my lord. Thereafter, it was not listed, my lord. The next week, any day, my lord. On order from my lord. They are enjoying the stay order. I am the maintenance case, my lord. I am the wife, my lord. The case is 2020.
Possible on 9th, not prior to that. Possible on 9th.
I beg to mention item number 22, my lord.
Hmm.
And next week, my lord, any date, my lord.
Let the matter reach. These are all 2010 matters.
Yes, my lord.
Okay. This state you cannot pass an order for adjournment.
My lord, another pair, my lord, I beg to mention for listing one criminal revision, my lord. In a NI Act, my lord, NI case, my lord.
Is it pending or it's a new case?
My lord.
Is it pending or it's a new
Pending. And next week, my lord, any date.
week thereafter? Week commencing from 5th.
Huh?
Week commencing from 5th.
Fifth. Yes.
Similar prayer, my lord. This my lord, similar petition, my lord, pending, my lord. So, my lord, my prayer, my lord, on second of this, my lord, because this the another case, my lord, criminal case, my lord, in before CGM is 4th of this August, my lord. So
It will on maybe on 5th, not before that.
maybe
May I please, Your Lordship? Lordship, I pray
No, no,
for withdrawal of
after
a
fifth, madam.
criminal petition to be listed tomorrow, madam. To be listed tomorrow. No.
Maybe the lordship. So I need to mention item number 12, lordship, for passover for the day, lordship.
Okay, let the matter reach, we'll see. Don't worry.
Lordship,
Let the matter reach, we'll pass order, not now.
so in this case,
Okay.
lordship, on the last day, notice was issued to the respondent number 2, lordship. Lordship, due to some miscommunication with my Mohori, step was not taken. That's why I'm praying for the
Have you taken
adjournment and
steps?
meeting.
You take steps in the during the course of the
During the courses of the, I will take this.
then let us know. We'll take care of it. Don't worry.
Lordship.
May I please, Lordship? Lordship, I'd like to mention item number 5, Your Lordship, for the petition side.
Okay, let
I
the
pray for
matter reach.
adjournment, Your
We'll
Lordship.
pass the order. Let the matter reach.
Item number 5.
We have 3 case diaries here, Lordship. In fact, none of us had seen it in this matter, 1 and 2, for Koshing.
On some time.
We'll go through it today.
3 case diaries.
No, 3 case diaries. Two case diaries. 2 case diaries, sir.
Mr. Bhattacharya, give us a date according to your suitability. We'll consider. Give us a date.
Today only we can see it.
10 days. 10 days time. Mr. Raha, just see when Mr. Bhattacharya is available
My lord.
and just see, give us a date.
My lord.
Or first week of August.
First week of August.
We'll have to
Maybe.
retain it, so a lesser number of days, we'll have to retain it. Of course, provided he can come.
13.
Second week of August, huh?
Oh, second week of August,
13.
13.
13 वाले case diary थोड़ी scan copy करे.
Is there need not be written, photocopies can be kept, scan copies.
अच्छा. तो photocopy करी because पठाई.
14th? Ms. Zahan, 14th will do?
14th, yes.
Solve.
14th August.
What we'll
Scan
do
copy of
is, we'll get it photostated and then we'll keep it and return the original.
For that, perhaps there will be order, other office will not send it.
No, they have the records, they have received the case diaries. So it is up to the, not required. Lika. Heard Mr. A.K. Bhattacharya and its senior counsel assisted by Mr. S.R. Rava, counsel for the petitions.
कितनी हेरी को बाहर. Photostat.
Also heard MS S. Zahan, learned additional public prosecutor appearing for the states. Ms. Zahan submitted that she has received the relevant case diaries and need some time to go through it. Prayer allowed on the prayer of the council for the parties released on 14th of August for admission.
Not, obliged. Java sir.
May I please your lordship, this matter will be kindly passed over for the day, because my senior lacks in court number 7, one part out matter is going on. May I please your lordship? Lordship, I filed under section 389 in a connected appeal. And I'm for the petitioner. I've been serving the sentence since last 2 years, 2 months and 12 days. Since 13/5/2022, the date of judgment, I have been serving the sentence. The appellant petitioner, he has been awarded a punishment of 7 years imprisonment with a fine of ₹10,000 in default of that extended up to 2 months more under section 304 part 2. My lord, the petitioner is a local man there and having his own property, and there is no chance if he is no chance of absconding if he is allowed to go on bail, my lord. And as per the previous records, he was sincerely attending the proceedings during the trial. And as he is the only earning member in his family, the family is having a hard time. And another point to be highlighted is that, my lord, considering the all aspects of his this matter, the petitioner may kindly allowed to enlarge on bail and till the disposal of this connected appeal. And my lord,
Petitioner copy.
my lord, he petitioner could not prove himself innocence. So I, on behalf of
Ms.
the
Zahan,
Lordship.
this appeal has not yet been admitted.
Today it has come up for admission.
Oh,
So let it be admitted and
That's
then
what-
call for the records. Of course, as far as the bail is concerned.
no, initially there was a delay, so delay was condoned.
yes, my
Thereafter,
lord.
it has been numbered and it has come forward.
Since he is incarcerated for how many years? 7 years.
Yes. And now 2 years, 2 months, 12 days ongoing as of today.
He is on previous bail, no?
No, behind the bar.
Lordship can consider the bail application after receipt of the LCR or.
My lord, among 12 of the witnesses, there were 2 IOs and MO. There were 12 of the eyewitness, they were being examined.
You are Miss,
As Medhi, my lord.
full name,
Legal aid counsel, Sunita Medhi. My lord, humble player, another. My name is not being reflected in the cause
we'll take
list.
care of, that's what.
Yes, my lord.
Mr. Anjad Ahmed's name is there.
Yes, I think previously he was being handling this case. I was being appointed as legal aid counsel since 28th of August, 2023.
She is being replaced. I don't know what has
He
happened to him.
replaced Angela, when he earlier, I think so, had an application that he will not be able to appear,
Okay.
something like that.
Okay, in that case, it's.
Her MS Sunita Medhi, learned legal aid counsel for the convicted appellant. Also heard MS as Zahan, learned additional public prosecutor for the state. Being aggrieved with the impugned judgment of conviction and sentence dated 13/05/2022, passed by learned Sessions Judge Golaghat in Sessions case number 34/2019, arising out of GR case number 139/2019, put in bracket Chungajan, CHUNGAJN. Police station case number 6/2019. Whereby he was convicted under section 304 within bracket part 2 IPC, sentencing him to undergo rigorous imprisonment for 7 years with fine of rupees 10,000, in default to undergo RI for another 2 months. The appellant from jail has preferred this statutory appeal. Appeal be admitted for hearing. Call for the records of Sessions case number 34/2019 from the court of learned Sessions Judge Golaghat, decided on 13/05/2022, along with the records of here case number 40, police station case number 5. Placed on 29th of thirtieth of August,
Yeah, please.
the
Yeah. Pardon, my lord.
The records.
Then 38, can it be altered? Actually, I have got another 2 cases, my lord. 1st of August.
you will not reach the case records, you will get it from Golaghat. So 1st of
My
August,
lord, you are suggesting 30th of August.
August,
Okay, then it's okay, my lord.
30th of August.
I have mistaken.
The interim prayer of the petitioner shall be considered only after receipt of the relevant records from the conference. Well, list of-
I'm highly obliged, my lord.
Oh, 5,000 before. It's not different.
We received the case records of local police.
Case study receipt.
Yes, ma'am, have you gone through the record?
No, Shiv, I have to go through
Oh. What is the relevant section? 294, I believe.
294.
Now, just read the FIR and the 161 statement of the informant and her husband.
No,
Read it. For yourself, you read.
no.
First, you read the FIR. Yes.
Happy. Your lordship, I'm for item number 5. I paid for adjournment, your lordship.
Take your seat. Take your seat. Read the FIR for yourself. You read it?
FIR.
Then you read the FIR.
Yes, sir.
Then go to 161 statement of the informant.
Statement of informant.
But Ms. Zahan, the concern IO has a very good handwriting.
Lordship,
Concern IO has very good handwriting.
very good handwriting, then I can read it.
Appreciate.
Lordship, yes. And it's so clean.
Then you read the statement, 161 statement of informant's husband.
Mm.
রিভিউ করে অনেক কম্পিউটার রেটিং দিয়ে রিভিউ শেয়ার করিব চেষ্টা করে করে প্রভাব ফেলা নাও হাজব্যান্ড স্টেটমেন্ট বস
Yes, you have read.
দীপজ্যোতি দত্ত আমরা আমার কোম্পানি ফোনটো রিসিভ লাস্ট পেপার করে হয়েছিল ফোনটো আমার এমপ্লয়ি অনুকা বলে জানাচ্ছি কেউ ফোন করে রিঙ্কি করে ছুটি বিচাৰে কিন্তু ৰিঙ্কিয়ে ছুটি দিব নোৱাৰিল কোৱা বাবে ৰিঙ্কিক বহুত বেয়া ব্যৱহাৰ কৰালেও বেয়া ভাষা প্ৰয়োগ কৰি গালি দিয়ে মই অনুসাৰে কোৱা সকলো কথা নিজে কাণেৰে শুনা পাওঁ
Now, what is in the FIR? If you see, you must have to first find out the ingredients of section 294 IPC, and then you just see in the FIR, just there is a mention that the leave could not be granted to the concerned employer,
yes
right?
sir.
The not concerned employee, it's the accused. Now, if you see from the statement of the informant in her 161 statement, you will see it was in the afternoon. If you also read the statement of the 161 statement of the husband of the informant, it is in the afternoon. But there is no such mention when such leave was sought for,
Yes sir.
whether in the morning and after leave was refused for that day in the afternoon.
Yes sir.
So something is not clear from both in the FIR as well in the 161 statement and of both the petitioner and her husband. Something, because that's what I found in the FIR also, the statement is made that leave could not be granted to her. And then she resigned through WhatsApp message and abused by giving a call, used abusive language. That's what is right. Since petitioner is seeking time and the counsel for the respondent number 2 is also not here, so his name has been reflected. You go through it whether it's a case for 482 or not,
Not.
because for 294 IPC there are specific ingredients, and
In a
where it
public
is,
place and
it
all.
has to be where.
Yes sir.
Now, whether it will come under IT Act or not, right?
Not.
So look at all these aspects and tell us on the next step.
Not.
What's your good name?
হচ্ছে যে এই কাজে
On behalf of Mr. Articles for the petition. Hard MS.
And that's not.
Full name?
Nandita das.
Current additional public prosecutor. For the state respondent number 1. None appeared for the respondent number 2 informed. No name of the counsel has been, no name of our counsel has been reflected in the corpus. even on last occasion, the respondent number 2 remained unrepresented. Ms. Dusk learned additional public prosecutor submit that she has received the relevant page diary. Mr. Kazi on behalf of Learned Counsel on behalf of Mr. Narkipatsa prays for some time. Prayer allowed. List on. 7th of August.
Meet Visual. Look, my rejection of my petition.
No, file now. Time, Baba? No, question?
11.
311. Additional evidence? No. Cross examination. 319 or 11 or মাজত মোৰ সদায় confusion হয়। কপিয়ে নহয় পাতি। অ'। তুমি এইখিনি দিল বড়ো। কিবা এখন কি ন? এই ৰিপৰ্ট আহিছে পইচা ন?
Take your seats.
Local usually absent. I mean, local. Okay. We can, okay. Okay.
Mr. Lal, have you annexed your application that you have filed
Lordship, yes,
earlier for recalling of the PW
yes,
one?
Lord. Definitely, Lord.
Have you annexed your,
Yes, Lordship. Page 52, Lord.
page 52?
Lord.
No, this is the application which you have filed later, or the first one.
Lord, this is the second application, Lord.
Where is your first application?
First application, we have
Which
not.
was rejected by the learned.
That was not,
judge?
that is not an.
Because in the order it is found that the learned trial court assistant session judge have considered that the similar questions
Lordship.
were earlier
Rejected, yes.
been involved, and accordingly the learned session judge rejected your prayer,
Lord.
right?
Right.
So where is your application, first application?
First application, we have not annexed. Lord.
See, basically we have seen that the, as you have mentioned, in the prosecution number 124,
Lord.
the evidence was recorded in, it doesn't look like, let us see.
Lord. When I was in custody, Lord.
Just a minute.
Page 55, Lord.
PW1 was, the statement of the evidence of the PW1 was recorded
That's it.
on,
PW1 lot.
was recorded on 16/11/2022.
That's it.
PW2 and 3 evidence recorded on 29th of November 2022.
That's it.
And PW4 evidence was recorded on 13 December, I think so,
That's it.
or 13 December
That's it.
2022. And in these 3 dates,
That's it.
we were in the court
That's it.
because we are produced from the jail hazard.
That's
Number 1. Number 2, the finding of the learned assistant session judge while rejecting your order on the 3/11 found that the questions which you have raised earlier for recalling of the PW1 is the same as that of the present petition. And against the earlier order, you have not preferred any revision petition,
That's it. No, if your lot.
right?
Right.
And then it is also a fact in 311 statement, when the question was asked,
That's it.
it simply rejects saying that you are innocent.
That's it. I adduce defense evidence in the matter.
So tell us, when earlier with a similar set of questions, your case was rejected, your calling for the PW1 was rejected. And with the same set of questions,
That's it.
you are coming for the second
Lord,
time.
there are two aspects of the
You
matter.
have seen, you have read your petition.
Yes, Lord. Now, there
Tell
are two aspects of the matter. First is, my Lord, whether the question is, my Lord, whether successive application is permissible under section 311 or not. The
So the
second
state-
question, Lord,
We are talking about the state.
Lordship.
After 313, you did not
Yes,
produce any evidence.
then it
There are
becomes, the
two
second
witnesses
application
to
becomes
the-
a successive application, Lord. And second question that will come up, Lord, because we have challenged both the orders, Lord, in this petition, the reject successive application, even if Lordship held, Lord, that it was not permissible, Lord, then also a petition will not be barred. And third, Lord, if Lordship has gone through the order of the learned trial court, Lord, it deals with everything, Lord, except the fact whether the evidence of the victim was essential for the just decision of the case. That is what recently in 2022 Justice Chandrachud has held, Lord. So that is the principal criteria on which the 311 petition has to be decided, Lord. Third, Lord, 311 has always to be read with 165 of the Indian Evidence Act, Lord. It imposes a duty on the judge, Lord, if the prosecution or the defense fails to conduct their case properly. That was also not done here in the matter. So all these circumstances are there, my Lord.
And most importantly, my lord, I was in custody during the examination of all these witnesses. The victim was represented by a lawyer, my lord.
Yes, Ma'am Jahan.
Lordship, in fact, the questions that Lordship had seen, it's reflected in the session judge's order. That whether she had relationship with the accused, whether the neighbors had confronted her, those questions, Lordship will see her statement. PW1 statement. Those questions are not relevant for the just decision of the case. She said she had informed her husband, who was not there, who was working elsewhere, and she said villagers came and hearing their voices, he fled. So these questions and other questions, Lordship will see. At page number 67, I can see whether she has been having an affair, that is ruled out. Whether she has invited the accused petitioner come to her, there's no question of that. Whether the neighbors had confronted her, neighbors had come. Whether her husband had found out about the petitioner's visit.
My lord, if Lordship is hearing the matter, let me be heard first, my lord. in the matter.
Achha.
You're
That's it,
asking only
Lord.
Miss Jahan. You're not hearing. She is pointing out.
That's it,
She's pointing.
Lordship.
Yes.
And
The one
then,
aspect of the matter is, my lord, if we put all the questions, my lord, in the petition, my lord, they are represented by an engaged counsel, my lord. The element of surprise of cross-examination will go. Nothing will remain. So you cannot put all the, that is there in the petition itself also, my lord, we have reflected that we cannot put all the questions before the court, my lord, in the petition, my lord.
that is okay, but
More particularly when they are represented by an engaged counsel, my lord, where there will be no element of surprise.
in fact, it is no res integra. It has been held by the Supreme Court that the facts which were known when she was examined, those facts, if they want to again bring through re-examination or calling again, that will be like loopholes, settling the loopholes. Counsel was there, he examined, cross-examination was done.
The judgments, my lord, of the apex court as well as the Guwahati High Court, the base judgments of the Guwahati High Court, Justice Mir Alfaz Ali, my lord, one case judgment, my lord. It says that Sessions case, serious offense, the accused in such circumstances ought to given one further opportunity. 10-line judgment, but we'll go through all this, my lord.
What we have, because here I think argument stage has reached. No,
Yes, absolutely.
matter is almost over. And it is like
And
delaying the matter.
I'm looking forward for a death life imprisonment, my lord. That may be a possibility. Only thing the prosecution loses is bring the witness again, my lord, in the top.
Medical evidence also, he wants to put certain questions. This is a case of 376 now.
Okay.
376, her statement would be enough, consistent statement before all the authorities.
Petition of appearance. Petition of appearance.
Yeah, of course, there are so many judgments here and there, both sides.
Justice.
It all depends on facts. Understood.
The case doesn't mention. Please put it previous law only.
Actually.
And practice on middle of the one.
Divorce and judgment, zero? Yeah, say 311, no?
Just to avoid that.
As in a plan.
When I was working in a domicile, one police duty as well. Okay, thank you so much. Process.
Oh.
It's so difficult to go. It's actually very good. Yes, I can tell you.
311. 311 तो बहुत इंटर हो गई पर कितनी है ना कितने भारी भी से तो जॉब डिसीजन हो चलिए because in 7 5 the family is a that is a factor so to say then for the ends of justice but then that will be the data witness recording so 2 days for 3 witness and I can do for some In one of the cases of 2017, there I found that it was of course a case under PC Act. And the prayer was made to recall 2 witnesses. For the ends of justice, the Honorable Supreme Court said that allowed the petition, saying that 2 days for 2 witnesses, not more than that.
That is fair enough, Lord.
Yes, Mr. Lal.
It all depends on
Yes,
facts and
See,
circumstances.
basically, it's a fair trial and that is goes to always in the available for the accused. But what we have to see that whether it is dilatory tactic or whatever,
Hmm.
like to that is what the main issue.
That's it.
Probably, anyway,
If your lordship has seen the FIR 161 and 162
we'll
statement, my
go
lord.
to date. That is it. Yes, please us. Please
Lord.
tell us.
My lord, let us come to page 11 of my petition, my lord. Lordship has gone through the impugned order, my lord.
Hmm.
Page 11 of my petition, lord.
Hmm.
That is respectfully submitted to the learned trial court in order dated 6/4/2024 was pleased to reject the petition on 2 principal grounds. The accused has earlier also preferred a petition under section 311 CRPC to recall PW1, the victim, for further cross-examination. The aforesaid petition was rejected by the order dated 11/7/2023, and this court, being a criminal court, lacks the jurisdiction to review its own order. That the accused did not prefer any petition soon after the closure of the defense evidence, and as such, there is delay and laches on the part of the accused. Now, page 17, Lord, page 12, Lordship, paragraph 18. There are 2 questions, Lord. Whether in the facts and circumstances of the case, further cross-examination of the victim is essential for the judge decision of the case, and whether successive application is permissible under section 311. These are the 2 questions before this honorable court, Lord. Now, whether even if your lordship held, my lord, that successive application is not permissible, we have challenged both the order, my lord, of 11/7/2023 as well as this order, my lord. So that will also not be barred if your lordship comes to a conclusion that the decision in examination of the victim is essential for the just decision of this case, my lord. So before we come to the facts, my lordship has already gone to the evidence. I will take your lordship to 2 judgments. One, the scope of 311 and one of Justice Chandrachud, my lord. In such circumstances, what he has held, my lord, in the matter. Very clear judgment, my lord. You can start with giving judgment to Jagannath. Very small 2 paragraph judgment, my lord.
Where is the first order?
Lordship, first order, my lord, is page 51, my lord.
So this is
Very cryptic order, my lord, and
page.
page 51, 51, my lord. 3rd paragraph, lordship. Heard both sides on a petition number so and so, dated so and so, filed by the Learned Defense Counsel, praying for recalling the victim for further cross-examination. It is submitted by the Learned Defense Counsel. The course of cross-examination of PW1, certain material facts were not put to her. The answer to this material fact would be relevant for proper adjudication of the. I've gone through the evidence of tendered by PW1 and also cross-examination, and I believe there is no necessity to call the victim as witness. And the petition number 8 now dated now is rejected.
Ms. Zahan,
Lordship.
page 51, 3rd paragraph. The finding of the learned session judge.
Yes, I've seen it.
So it is to fill up the lacuna. If you find out that this is recorded by the learned session judge, it is clear that it's only to fill up the lacuna.
The answer to those material facts would be relevant in the proper
So
decision.
before the line thereafter, that just before that, the line, it is submitted.
It is submitted by the Learned Defense Counsel that in the course of cross-examination of PW1, certain material facts were not put to her. The answer to those material facts would be relevant. I've gone through and also the cross, I believe there is no
This
necessity to
this
record.
finding itself is to fill up the lacuna.
This is what it shows. It's like filling up the lacuna.
Well, the question would be whether filling up the lacuna in such
See,
second.
Mr. Lal, why you have not annexed the petition? Why you have annexed the second petition?
If Lordship permits, we will annex the filing a additional affidavit, my lord. If your Lordship takes up, my lord,
Just a- Ms. Zahan, please come to para 8 of the petitioner in his, she
Okay.
was on second petition, page 56.
Page 26, this
Page
is
56, 56.
56. Hmm. Yeah. Paragraph Lordship want me to see.
6, only 6,
Six.
paragraph 8.
8 are those questions. It's like filling up the lacuna because what I said, having an affair, she called her husband immediately on that night. This is what she said in her
It's
examination.
clear if you read the paragraph 8.
That the accused petitioner most humbly submits that when the prosecutrix was cross-examined, she could not be cross-examined on many vital facts, including. This is what he's saying is exclusive, not.
That's purely
yes.
filling up the lacuna.
But he's saying it's not exhaustive. There can be other questions. Whether she has been having an affair, whether she has invited the accused, whether the neighbors had confronted her.
Petitioner did not annex that letter.
Yes, sir.
Had it been annexed, something else could have been happened. That would have been sufficient.
Yes,
The copy of the letter petitioner did not annex.
Yeah.
Now only it could be placed before the court. Okay, we'll dispose it off.
Lord,
Give us the record, we'll return you to some time.
Lord.
Who ordered it? Or Mr. Ashok, not counsel for the petition. And it's, and us, right?
Right.
Original public prosecutor. For the state. Measure of one Messrs. DA Motors Romania informed the police the Romania informed the inspector, the officer in charge of Romania police station on 31/10/2023 around 12:30 PM. 12:30 hours ago. Informs us that since 19/10/2023, a dumper bearing registration number AS 14C1112 have been parked in front of their Tata Motor workshop. And although he was requesting the owner, public driver of the said vehicle to take away, to take it away, to take it away. But for the last 10 days, the said vehicle was kept parked, first partly in front of their workshop that caused trouble for other vehicles to ingress or egress the said workshop. On receipt of the said information, JD entry number 027 dated 31/10/2023 was made. And one assistant sub-inspector was entrusted to was made. And accordingly, one assistant sub-inspector of said police station was endorsed with the case. Accordingly, the concerned ASI proceeded to the place of occurrence, seized the said Tata whatever vehicle dumper number substitute on abundant condition by preparing seizure list dated 31/20. Tata dumper vehicle. And they said seizure list was produced to place before the learned subdivision judicial magistrate within bracket opposite bracket close district number Pacham, white MR number 210/23. On 03/11/2023. Along with the photocopy of the seized vehicle. It says seized vehicle. The learned as the same, didn't look at him, yeah. After perusing the said seizure list, find MR number 21023 by order dated 03/11/2023. In Romania, GTN number, GTN number 27. Recorded the same along with the photography and returned the memo, says a memo, to the concerned investigating officer directing the state authority to keep the copy of the same crime with the case record. It is seen that the concerned investigating officer after seizing the said Tata dumper vehicle inform number vehicle number, inform its registered owner by the petitioner about the seizing of the said vehicle. SCA data identity. And also about replacing the said signal remove for the landed as the ZM within bracket Amrania. And further inform him that the said vehicle, said Tata dumper, that his said Tata dumper vehicle has been now after seizure is in parked at ENU unused ENUSC or Kings Ronia. Thereafter, the petitioner on fourteen 11/2023, they informed the petitioner by post. Intimated the petitioner and informed about success to post. On 14/11/2023, the petitioner filed his IMA petition bearing number 672 before the London SDJ within bracket Romania. In said Romania PSDT entry number 272023. For Zimma of this, Zimma of his say Tata dumper vehicle number. Seized in connection, seized by the concerned investigating officer in connection with Romeo PSDT number 57. However, the London JMFC, sorry, SDJM, Romeo, limited and Romeo Kamrup, by order dated 14/11/2023, considering the fact that the matter is in the investigation says the said seized vehicle was produced before the said court by demand number 210/2023. And the criminal court has only the jurisdiction to give custody of such seized property of like article at the stage of investigation only when those seized property are not produced before the court. And as the seized vehicle was produced before the said court, but the concerned investigating officer by demand number 210/2023 and the investigation the London SDJM by order dated 14/11/2023 rejected the Zimmer petition of the said vehicle number referred by the against the same order against the state of the 15 of the London circumstance. The petitioner preferred a criminal revision petition. Petitioner preferred revision petition before the London additional session judge Ramia Kambu. Being criminal revision number 08 of 2023. And the London additional session judge Ramia, after hearing the land council for the purchase by order dated 08/04/2024, considering the provision of section 451 and 457 of the Code of Criminal Procedure, and judgment of coordinate bench of this court passed in criminal petition number 284/2022. Rejected said criminal division petition preferred by the petitioner upholding the order dated 14/11/2023 passed by London SDJM and Romania, rejecting the interim remark of the seized vehicle seized in said Romania PS the entry number such. Hence this criminal petition by the petitioner. This court By order the 07062024. Call for the report from the concerned investigating officer. Regarding the registered owner and Zimma of the vehicle involved in the process. Mislead us, and that's it. An additional public prosecutor to replace the relevant records of Ramya ZTE entry number 27 dated 21/10/2023 in which the said Tata Dumper vehicle bearing number 66 was seized in presence of witnesses in front of the concerned workshop. 31/10. And also place the communication dated 19/07/2024 of the concerned investigation officer of that case forwarded by the inspector from officer in charge of India police station. From here. It is seen from the records of the case that the investigating officer of the entry number such and such inform the petitioner, registered owner of the said Tata Dumper vehicle bearing registration number seized in said the number 170, which is placed before the land for this during the time. Wrong here. No, I'm not. The photograph of the same. Any postal address. By the said communication dated 19/07/2025. Concerned investigating officer of the case also placed before the court that the petitioner did not approach the concerned police station to take the man of the said seized vehicle. Is said seized vehicle. Is the legal said vehicle. On perusal of the records, is seen that the concerned investigating officer of the by his communication dated 07/11/2023 informed the petitioner in his postal address by a letter to post intimated them, regarding the seizure of his said Tata Dumper vehicle number such and such. The reasons for such seizing and also about that the said seizure along with the seizure memo and the photograph of the vehicle was placed before the London Approval of the statement. Says seized the place before the land has design remote academy. And that the said vehicle after seizing on 31/10/2023 in park at TNUS parking from here. And requested the petitioner to approach the court of honorable as designed in the Catalonia. Ultima of the city. Probably after receipt of decide letter from the concerned investigating officer of this pertaining to the seizing of his said vehicle, Dongia appears in the petitioner. File the appropriate application. File the application under such and such for Zimmer of the said. Part of the appropriate level. It is seen that since the date of said seizing vehicle 31/10/2023, for about 9 months. It said that a comfort of the petitioner was parked since the petitioner was in court. The unused parking at Dongia under sunlight. Considering the interest of the as the concerned investigating officer found the petitioner to be the registered owner of the said vehicle bearing the marks of the charge. He is directed to approach the officer in charge of Ronia Police Station or the mouth they say such and such. Seized on such and such, who connects with each other, remain the deed of on a such approach, a the said vehicle such and such is not required for the investigation. After taking photograph, let's give you of the vehicle along with engine number, system. And on proper identification of the petitioners that he being the registered owner of the trade. The same shall be released to the petition. On condition that he said produce the said vehicle before the court. Whenever it is required for. Let's- yeah. Let's say before the police, when it's an investigation of the case, and whenever it is required, it's by the court in connection with CTP. We'll put some more condition.
Yeah.
We'll put the record for some time.
Right. Obliged.
May please, your lordship, this is an statutory appeal, lordship. The appellant convicted under section 326 and 307 of IPC, lordship, for 3 years, lordship.
32.
Lordship, here in this case, lordship, 2 persons named in the FIR, lordship. And after completion of investigation, lordship, and before starting trial, lordship, the husband of the appellant, lordship, died.
This has come up for the first time, Lordship,
Yes,
and
yes,
admitted.
Lordship admit, and the appellant,
Mr. Azad Ahmed,
Ayu Chaudhary, lordship.
I.U. Chaudhary. Full name?
Imran Uddin Chaudhary, lordship. The appellant now he is on previous bail, lordship.
Acha. Sir.
It is in the petition you have said appellant is in jail. How can you say that he is in previous jail? Page number 3, first title.
Lordship may peruse page paragraph 9, lordship.
Which one is correct?
I lordship. Page 8, para 9,
Which
lordship.
one is correct?
Lordship may take I lordship.
Where is the order of the trial court? Allowing you to live in.
Lordship.
There is no averment that she may remain on previous bail.
Lordship order dated 24/6/2024, lordship.
You have not mentioned anything. You should have bring it by notice of an application.
Lordship, I have mentioned in para 9, lordship, of I lordship.
But then the document should be there. What is it? Can we likhi diya na? Neither that surrender part is written, huh? I hate this issue.
Para 9 plus.
Paragraph 9 is your pleading. Into advancement of 9?
Extra order as well.
What is it? 9 দেখুন।
Last page.
Oh, seen the petition being filed by the accused petitioner trying to allow.
Letter on.
Yes, that previous bail is allowed by different order, 24/6/24.
24/6/24. Last page, lordship.
Am I at 9?
You can look on.
Demand, conviction demand.
3 years.
3 years. So. One asset section.
336/307.
No, is a previous bail, there is a petty offense on the 389 it has, no?
Read para 9. Page 8.
Page 8, para 9, lordship, that the applicant begs, so during trial, she was all along on bail, and subsequently following his conviction, the learned trial.
Following his conviction. Then Read.
Allowed,
Allowed him,
sorry.
his
there is-
conviction, allowed him.
there
This is
type-
copy
What is
paste.
this?
Typographical error.
Don't take it so lightly.
In paragraph 9.
Paragraph.
Don't take it so lightly.
Extremely sorry, Lord.
No. Saying sorry is not enough. That is why you are saying the condition of the bar. Ask Mr. Agarwal sitting behind you what they used to do during the daytime.
Lord.
What kind of
I'm
tough
extremely sorry,
situations were
Lord.
there?
But I may be allowed to correct.
Tell us what is the petition number by which you filed before the Granite Sessions Court.
Lordship, petition number mentioned, Lordship.
Number 90.
Number is not mentioned,
You
Lordship.
should know. You have preferred this appeal, you have preferred this application.
Lordship,
You should know, you should have inquired.
Lordship.
Did you mention in this petition? Your application?
No, Lordship, petition number is not there, Lordship.
Heard Mr. Ravi Chaudhary. Not counsel for the appellant. Convicted appellant. And MS as the Learned additional public prosecutor. For the respondent. But the impugned judgment and order. Twenty-four 06-2024. Learned. Sessions Judge Karimganj. Convicted. The appellant. Under sections 326/307 IPC. And sentence her to undergo rigorous imprisonment for 3 years with fine of rupees 5,000. In default to undergo simple revision for 6 months for committing the offense under section 326 IPC, and further to undergo RI for 3 years with fine of rupees 5,000, in default to undergo further SI for 6 months for committing the offense under section 307 IPC, where both the sentences to run concurrent. Aggrieved. What do you say?
Bail order time to develop.
Conviction and sentence dated 24/06/2024, passed by Learned Sessions Judge Karimganj in Sessions case number 59 of the 2015, arising out of Ramakrishna Nagar Police Station case number 92 of the 2011.
24.
The appellant has concurred this delivery appeal. Appeal will be admitted for hearing. Call for the records of Sessions case number 59 of the 2015 from the Court of Learned Sessions Judge Karimganj, along with the case records of RK Nagar PS case number 92 of the 2011. List on. 30th of August.
I think his previous bail will expire today because the
Let's-
order reflects fixing 25/7 for necessary order.
First necessary order.
Either they have to file an application
The
there for,
applicant, they have to file, the applicant as an appellant, I had to click. But the hard copy.
without NCRT at Nitivo. 3 years, sir.
Refer the connected appeal.
Our lordship can
Challenge.
allow the bail here,
Will con.
a lot.
Convicting her. The sections 3 to 6 copy coding and sentence. Judgment, conviction, that is 24062024. Past in sessions case number 59 of the 2005. Everything of the- The said appeal of the applicant has already been admitted for care. By order. By order passed to the said appeal. Sentence to the court by order passed to the applicant. Same has already been admitted. By this application. The applicant has prayed for stay of the operation of the judgment, said judgment and order of conviction that the 24/06/2026 filed by London Session Judge Karim in sessions case number 59. And allow her to go on previous bail or principal. The Mr. Chaudhary, Ayu Chaudhary, legal and counsel for the applicant have also placed a copy of the order dated 24/06/2024. Passed by Leonard Session Judge Karimganj in sessions case number 59 of 2015. Whereby on her prayer after such conviction and sentence allowed her to remain on previous bail. Tara kotate sentence. It is to be stated hearing that during the trial of the same business case number such and such, the applicant was on bail. That's the giver after 40 months of contempt. On previous bail, as she submitted that she would prefer an appeal and in the said judgment of conviction and sentence dated 24/06/2024 and fix the matter today. As the records of the London Session Judge and the connected appeal numbers and fixed said matter on certain field and I certain such. The applicant is allowed to remain on previous bail and this application shall be considered only up to perusal of the case records. Yes, accordingly on such and such along. We have extended that bail only up to 30th of August. We'll consider after the records. We have not disposed of this application at this stage. We'll see. একটু সোনকালে মাৰি আপলোড কৰি দিম।
Problem. नहीं तो याते extension कर दिले तो याते extension कर दिले तो just गुफले दिले हुआ है ये हाँ अभी तो order start होगा order start होगा
कब होगा
हाँ 8 से अभी start होगा you come 2:30
অটোমেটিক এড হয়ে থাকে
হ্যাঁ আছে বাট স্কুলে হলো হ্যাঁ আছে হ্যাঁ সিঙ্গার সিঙ্গার তো Oh, thank God. Oh.
ঠিক আছে ঠিক আছে
Item number 3.
Right. Sorry, on behalf of the petitioner.
When the matter was called, Junior said that he was on legs in some other court. Perhaps that is continuing. Oh, and legs are assembly procedure. One 38 proceeding, both sides are not present.
There is no stay order.
Perhaps yes, no, it's
No, there is no stay.
She will take it up next week then.
The first of counsel for the petitioner. Wait for consideration of this matter. Second, when this matter was called up in the second and just after 2 weeks on it, the week expired. Yes, Mr. Hello.
Lordship, the case where Lordship they filed a petition, this petition on the post 82 for quashing of the FIR registered by CBI. Lordship. This matters come up for order, Lordship. But to have been come for admission, Lordship. But that was not yet admitted, Lordship. Lordship, the matter relates to a PIL, originate from PIL, Lordship. That matter, Lordship, it's a old pending matter, Lordship. And in pursuance of this honorable court's order, Lordship, direction, Lordship, CBI conducted a preliminary inquiry, Lordship, and thereafter, Lordship, materials were found against the petitioner, and therefore also the regular case has been registered, Lordship.
No representation on behalf of the petitioner on call. Heard Mr. M. Haloi, Learned Standing Counsel, CBI. For the respondents. On reply of the counsel for the petitioner. By order dated 19/07/2024. This matter was fixed today. It is to be noted hearing that since 19/12/2019, there is no interim stay order in favor of the petitioner. No kind of interim order relating to what is the CBI case number?
RC number, RCC 382019, SHG PS CBI, ACB Shillong. Page number
Relating
27.
to CBI, SCB, CBI oblique ACB oblique case number RC 020 2019 A 0003 तीनटा 0 ठीक है ACB शिलोंग किंतु ना of 2019 within bracket RC CA 2019 SHG bracket close. Under section 120B/423 of the IPC, reduced sections 13 within bracket 2, oblique 13 within bracket 1 within bracket small d of the Prevention of the Corruption Act 1988. Okay. List of the 3 183 630 registered.
Talib.
May please your lordship. Office note dated 23/7/2024 may be registered. Service upon the respondent number 2 is complete. Oxon. DNA test.
DNA test. Hello, petition, huh?
Process server served the notice on the respondent number 2. Obtaining her thumb impression. But there was no witness
No
regarding
witness.
service of notice by the processor.
That is not mandatory, I believe,
But,
because section 262, I think, of the CRPC, or only 62, provides for service of notice to the normally they take witnesses, but service of compel appearance. Summons to the service of service officer.
Matter related to POCSO.
POCSO matter. Victim was herself served.
Informant.
Informant.
Informant is the victim. No,
No, no.
mother. Mother of the child. The victim. Mother of the victims.
The stay order is in force.
Lordship.
Stay order is in force.
Lordship, yes. In fact, the impugn order I've just seen. This is rejection of DNA examination at the fag end of the trial. And Lordship knows DNA examination will be, even if it comes out to be positive, it will be only a corroborative evidence. Which will be not be fatal to the prosecution case. As far because charges are under all POCSO Act.
The victim was made pregnant.
It is victim's child's and the accused had filed that application.
But today morning you have just read the judgment. Harsha Agarwal. What do you have to say in that?
Lordship,
Today morning you have just read the judgment. Harsha Agarwal.
Varsha Agarwal. Yes.
In that circumstance, it is not a case of gang rape or something. It was the accusation against a particular person. DNA test might give the result.
But it's a settled position, even if it comes out negative, that he is not the father of the child.
Whether they under the provision of POCSO Act, because POCSO Act has different.
Yes.
But even then, he might commit a offense under POCSO Act. The child
Even
may
if
not-
he is not the father.
Even he is not the father, definitely.
So it is said to be only a corroborative evidence if he is not a father. But otherwise, these sections will not go. And it's a reasoned order of the learned trial court.
No, if you come to page number, come to page number.
cover আচ্ছা আমরা সামলাবো
Read page 68.
Lordship. In view of the discussion.
Just the previous paper.
Moreover, more than 5 years have elapsed since the incident and no prayer for DNA examination has been made for the last 5 years. As per the averments made in the application, the victim has been murdered. Victim has been murdered.
Yes.
The accused has failed to disclose in whose custody the child of the victim currently is, or whether the child has been given in adoption. The court also has to give paramount consideration to the mental and physical health of the child. The law is well settled that details of adoptive parents cannot be disclosed. In view of the discussion made above, it is clear that in the case of the prayer of the accused for holding, DNA test cannot be allowed as during investigation or during the stage of charge or during the stage of trial, there was no attempt for holding DNA test. After closure of prosecution evidence, examination of accused under 313, and after disclosure of entire defense case, prosecution prayer to hold DNA, test of child of the victim and accused cannot be allowed to establish the offense under 376 of POCSO. Question of paternity of the child has no nexus to the alleged offense of rape and DNA test cannot be allowed. Whether determination of paternity of the child is relevant or not, through DNA test that is decided in a different forum and not in this case. DNA test is not to be directed as a mere matter of routine and only serving cases where strong prima facie case is made out, such direction may be given while duly keeping in mind the best interest of the child as well as the law laid down
No,
with
that's a
the
different part.
Lordship.
So now we are in that stage.
Mm.
Now, even if let us assume the child belongs to somebody else
Mm.
and the victim is no more. And the victim's statement was already recorded during the trial.
Mm.
So
Mm.
what will happen?
Mm. Victims in a suicide person. দিব পারে যেহেতু তো বাচ্চাটা মাকে না অ্যাডপ্টিভ পেরেন্টস এই ভিক্টিমের স্টেটমেন্ট দিছে নি ট্রায়াল কোর্টত তাৰপিছত সুইচাইড কৰিছে আৰু তাৰপিছত সুইচাইড বহুত জাজমেণ্টৰ আগত এইটো অহা নাই 313 পিছত কেনেকুৱা হৈছে 164 dia na, no? 164 dia na. Okay. Hmm? Oh, okay. আজি hearing কৰিব বিচাৰিছা নে? আজি hearing কৰিব বিচাৰিছা নে? Respondent to 9.
Okay, we'll just assume that we will not say anything much.
In fact, Supreme Court has said that at every stage the victim needs to be heard. Today they are not there. One. Now, no? Dante. Like that. One 53A, no? 153A, no? Oh, 53A. It's a 1 again. It's a 162. Good. The statement of who said, I have requested for DNA examination number of time. If full finding the was never done, it globally has come forward. It is very topics. Education and one. Can actually so the person we have not said. ये सैलरी तो कॉन्सेंट पे होता नहीं ये ना
Heard Mr. M. Ahmed, counsel for the petitioner. Also heard Mr. Jahan, an additional for the prosecutor for the state. Pursuant to the order dated 26/02/2024, passed earlier in this proceeding, the petitioner took steps on the response number 2 that was issued by this registry 10703/2024. While taking steps in usual process, as has been seen from the report of the process server, that while serving notice on the response number 2 informant, he did not take any signature while serving notice with them. Did not take any signature of any other witness. Registry is yet to receive the ID card or unserved notice. Matter be placed before the Lozima court. For its consideration and on order regarding service of notice on the response number 2 informant. Place this matter for order on 21st with the report of the Lozima.
21st of
The interim order passed earlier on 16/6/2023 shall remain in force till the next date of it.
21st of August.
Not. Hi, Lovelace. Hey, please, Lordship.
Yes, if file objection.
Before starting Lordship, we could not file our objection because Lordship, we could not find out our copy in our office, Lordship. Lordship, pray before Lordship, only a last chance may kindly be given, Lordship, so that we can file it. Lordship, I will collect a copy of petition from the council, Lordship. One more chance, Lordship. Okay.
Take your seat.
Sure.
Yeah.
Yeah. Thank you.
Yes, you see, you are placing certain judgment. Yes. What is it?
On on submission, Milord, Mayor. Judgment, Milord, there is 1996 to SCC.
Yes, what do you want to say from that?
In a, I'm reading, Milord.
Hmm.
Head note, I'm reading first, Milord.
Hmm.
Indian Penal Code, Milord, 1886, section 376. Case involving sexual molestation, duty of the court to deal with such cases with utmost sensitivity. Minor contradiction or insignificant discrepancies in the statement of the prosecutor should not be a ground for throwing out an otherwise reliable prosecution case. So, Milord, the minor discrepancy may be there, may not be there, but in no sense there is minor discrepancies may be there, but on that ground, prosecution case cannot be thrown out. Milord. And another, Milord, I am reading your lordship, there is a Ganeshan case, 2020, part 10, Milord, 2020-10, SCC 573, Milord. Of course, it is, Milord, under POXO Act, but wherein it is said, Milord, the head note I am reading first, Milord. For the testimony of victim is found reliable and trustworthy, regarded and conviction on the basis of her sole testimony is permissible. So sole testimony, conviction on the basis of sole testimony is also permissible. And on facts, Milord, I am reading on submission, Milord. Accused keep the victim from Milord 410 to 19 to 810 to 19 under his custody. Forcefully. And Milord, forcefully, Milord, committed sexual offense, Milord. And DW1, Milord, the appellant, Milord, lordship, he admitted that they lived as husband and wife. But there is no any document of marriage or Milord any valid other witness. And PW3, Milord, victim stated, Milord, before the court, lower court, Milord, that the offense committed under section, Milord, she stated clearly, Milord, that the offense is under section 373. And the person who, Milord, executed all this, Milord, a marriage agreement or affidavit, he was not advocate on the date, Milord, as because he did not pass the, Milord, all India bar exam. So all these points, Milord, my submission of lordship, bail may not be granted. Let the matter come up for final hearing. That's
But anything else you want to say?
My lord, may I submit?
Yes.
Lordship, here in this case, Lordship, 376 punishment is there, Lordship. So, Lordship, the victim's sole testimony is to be counted, Lordship. And in that case, Lordship, whether she is inconsistent or trustworthy, that has to be ascertained from the material available with the record, Lordship. In her 164 statement, Lordship, she has stated what she has stated in her 164 statement, and as a PW3, Lordship, that is inconsistent, she is inconsistent, Lordship. The material fact is that, Lordship, she has given 10,000 rupees. He asked her to bring to return it. Then she was kidnapped. Then he forcefully made physical relation with her, Lordship. In these four material facts, Lordship, she is all along, Lordship. From the very beginning, she is all along inconsistent, Lordship. So when she is inconsistent in all along, Lordship, so her testimony is trustworthy, Lordship. In that case, Lordship, the full sing judgment is the Lordship, dear Lordship. In Lordship, that is 2022 to SCC 74, Lordship. Full sing judgment is there. And where it is stated, Lordship, that Lordship, when the victim prosecutor is trustworthy and inconsistent in her all along, then on her sole testimony, the conviction can be given. And apart from that, lordship, what their claim is that they got married with her lordship. But lordship, that affidavit as well as that agreement, lordship, she denied that, lordship. She denied her signature in her cross part, lordship. She denied her signature, lordship. And when she denied her signature, there was no any prayer from the defense side that her signature may be sent for FSL like that, lordship. So that part, lordship, that affidavit that has that on the basis of that they cannot claim that she is her his married wife, lordship. And when she is not his married wife, lordship, legally married wife, lordship, anything done that is illegal, lordship. So, lordship, as she is all along, lordship, inconsistent, and she is so that we can say that she is trustworthy. And as a case of C-76, lordship, there may not be any case of direct evidence or direct eyewitness, lordship. So, lordship, our evidence on the basis of sole testimony of our evidence, lordship, she can be